equal justice where the kind of trial a man gets depends on the amount of money he has. Nowhere is this truer than in the issue of indigent defense. Our criminal justice system has been referred to as a three-legged stool supported by the courts, the prosecution, and the defense. If you remove one of these three legs, the stool collapses. Our Judiciary Committee has spent the last year spearheading a conversation about the third leg, the defense, and how it has collapsed. The committee has held 2 hearings on indigent defense last year in a forum on this issue in Michigan and received testimony from the APA, the NLADA, the Constitutional Project, the ACLU, prosecutors, professors, and judges. All agree that there is a serious crisis that must be addressed. In February, the Department of Justice held a national symposium on indigent defense where Attorney General Holder reiterated his commitment to addressing this crisis. And also in February, he established the Access to Justice Initiative in the Department of Justice and appointed Professor Lawrence Tribe, noted scholar and Harvard Law professor, to lead the effort, with particular emphasis to be placed on the issue of indigent defense. The indigent defense crisis is a serious problem for the criminal justice system as a whole and for our country, particularly when you consider that the third leg of the stool, the right to counsel, is the only leg that is actually constitutionally mandated. Back in 1963, the Supreme Court, Gideon v. Wainwright, ruled that this right required the appointment of counsel for a defendant charged with a serious crime and who could not afford to hire his own counsel. The Supreme Court later extended this right to counsel to juvenile proceedings and to misdemeanor cases where the defendant is subject to imprisonment. And despite the Supreme Court's rulings guaranteeing the right to counsel in criminal cases, many defendants are still denied effective or sometimes any representation. A number of studies on indigent defense conducted since Gideon have documented these problems. 2 significant reports were released last year that chronicled the extent of the crisis in both misdemeanor and felony cases. The first is a report from the National Right to Counsel Committee entitled Justice Denied, America's Continuing Neglect of Our Constitutional Right to Counsel. The other was prepared by the National Association of Criminal Defense Lawyers, and it is entitled Minor Crimes, Massive Waste, the Terrible Toll of America's Broken Misdemeanor Courts. It is undisputable that state indigent defense systems are in crisis, and it is time for the federal government to step in and address it. The studies show that about 90% of criminal defendants are indigent. They also show that there is a patchwork system or lack of a system of state and local governments having responsibility for indigent defense with varying degrees of inadequacies. It is not acceptable for us to keep funding only 2 legs of the stools, the courts and the prosecution, without regard for the impact that this creates on the defense responsibilities. Funding state and local enforcement operations, knowing that 90% of the charges they will bring will be against indigent defendants, results in an unfunded mandate. The committee is committed to helping states and localities address the indigent defense crisis, and we're working on various projects, both long-term and short-term, to do so. We've gathered information about the lack of funding and the extent of the disparity between the defense and the prosecution funding by way of a GAO request for a study, and we've been looking at how we can achieve these goals through legislation. At this summit, we have brought a diverse group of people together to talk about the state's crisis and the much-needed federal response. Of course, you will hear from defense advocates. We've also brought judges and prosecutors to talk about how this crisis adversely affects the entire criminal justice system and why they too want and need good defense counsel to do their jobs as judges and prosecutors. Together, we will explore how we can end the attitude that was made famous by a lawyer. I'm not sure whether it's actually true or not, but a lawyer was known to, or reputed to proclaim that all of his clients were innocent until proven indigent. And to move to a place where we reflect the words of the Supreme Court Justice Louis Mao, who said that equal justice under the law is not merely a caption on the facade of the Supreme Court building, it is perhaps the most inspiring ideal of our society. It is one of the ends for which our entire legal system exists. It is fundamental that our justice should be the same in substance and availability without regard to economic status. I'd like to recognize at this time the chairman of the full committee who has been working on this issue for years and has been working particularly in the state of Michigan on this issue. I'd like to recognize the chairman of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers.
Thank you very much, Chairman Bobby Scott. This is